Thank you. Please be seated. This is the time set for oral argument in Shug v. Arizona Board of Regents, our cause number 1CA CV130101. Counsel, you're probably aware that we've read the briefs and conferred on the matter before coming into court today, so you can bear that in mind. I'm required to let you know that you are, all of us are being video recorded in today's argument, and as with the prior argument, each side will have 20 minutes, but the amount of time that appellant wishes to allocate is up to you. All right, thanks, and with that we can begin.
Good morning, Your Honors. May it please the Court. My name's Richard Williams. Abigail Terhune is with me here today. I represent Michael Shug, the trustee of the bankruptcy estate of Michael Shug, who I'll refer to in my arguments as Shug or Mr. Shug as appropriate. I'd like to back up and talk about the big picture here for a moment. As the Court as the panel is aware from reading the briefs, we've been in two different lawsuits involving the state of Arizona. And what the dispute involves is an 80-year-old easement running to a fairly unique piece of land, 650.
Does it? I mean, is there an easement?
Our contention is that there is an easement. That factual determination has never been made by in either the Shug 1 case or the Shug 2 case, but it has been made by the Ninth Circuit Court of Appeals.
Well, the Shug 1 case out of Division 2 was fairly clear about the extent of your client's property interest, wasn't it?
It's in ruling against us on the statute of limitations issues. It found we didn't have the right to bring a future claim that we had a step to establish an easement, but there was never an adjudication of whether the underlying easement occurred. That's never happened.
What's the value of a right that can never be enforced?
That's what the purpose of the inverse condemnation action is for. We have a right that has existed for 80 years, and it's now been taken by the state. It's been lost, and the purpose of this action is to determine what the value of that right is.
Okay.
Now, it has been taken by the state. And I guess I'm having to kind of refocus my thinking here a bit on this one. Isn't what as we refer to it, I think, as Shug 1.
Yes, sir.
So we can keep them separate. Didn't that say that with the existence of the violation of the statute of limitations, as the court found, that you don't have a claim to an easement? Isn't that what they said?
What it says, and I have the language right here, plaintiff has no right, title, or interest in the Maricopa Agricultural Center and is barred forever and is stopped from claiming any right.
Isn't an easement an interest?
It is.
And that sounds pretty absolute to me.
It is, and that's the taking right there. That's where we lost our property interest in that decision by the court. The question for this court is 10 seconds before that ruling, did we have a property interest? And that's never been determined.
What gives this court the power to go back 10 seconds before another court of equal stature ruled?
The claim for inverse condemnation. That gave rise to the taking, and so this court has the power to determine whether just compensation should be paid for that.
So
I'm sorry.
So by bringing a second, or let's just say different, so by bringing a different cause of action, it effectively undoes the judgment of Shug 1 at the Court of Appeals, saying that your client has no interest in the property.
No. We're not disputing, we're not claiming an interest in the property as of today. That interest is gone. We agree that interest is gone. The question for this court is whether there should be any compensation for that.
That interest is gone because of a failure of the statute of limitations.
Yes, and together with the fact that the state constructed a gate and then brought a motion for summary judgment.
But the reason that the judgment says there's no interest in the land is that your client didn't comply with the statute of limitations. is there any law, public policy, case, statute that says that when a private citizen fails to abide by the statute of limitations, the state should be liable for that? That seems to turn takings law on its head. I mean,
Well, a taking can be by any branch of the government.
Are you asserting it was by the court?
I'm asserting by it's a combination of the court and the University of Arizona
And
in
so
combination.
So we're real clear on the record. It's your assertion that the court engaged in a taking when it granted the Board of Regents judgment based on their statute of limitations claim, that it was the court that actually engaged in the taking.
It's a combination of I believe it's a combination of the court and the University of Arizona. University of Arizona constructed the gate. They moved for summary judgment. There was an easement in place at that point. We've never been able to prove that, but that's our contention.
Aware of any case in the United States in which a court has engaged in a taking?
Any branch of
I'm not familiar with a court being
We've
able
looked
to
and
do that.
we haven't found any case exactly like this.
If that's the case, if the court was in fact, and I'm not being the least bit flippant about this, okay, I want to be real clear on this. If in fact the assertion is that in Shug 1, the Court of Appeals engaged in a taking, then wouldn't the Arizona Court of Appeals be a necessary party to Shug 2?
Let me rephrase that a little from how Your Honor has phrased it and see if I can clear this up a little bit. The taking occurred as a result of the decision by the Arizona courts. The property was returned back to the University of Arizona. It's University of Arizona that has the property, our property interest, that's now been extinguished. But it was extinguished as a result of a ruling by the Superior Court.
But every taking claim has a ruling by a court, positive or negative. A court at some point says there was a taking, there was not a taking. You're entitled to proceed with your damages under an inverse condemnation claim, or you're not.
And that's,
So
I'm
hang
sorry.
on. So is it then your position that the court that enters the order is guilty of the taking?
No, the court that enters the order isn't guilty of the taking, but as a result of that ruling, our claim was extinguished and returned to the University of Arizona.
But your claim was extinguished because your client didn't comply with the statute of limitations. I don't see how blowing the statute of limitations creates rights. The whole point of the statute of limitations is it defeats rights, and not in a way requiring compensation.
Well, we certainly couldn't.
I mean, if you had
Proceed
a
with
personal injury claim and didn't comply with the statute of limitations, and the court said you didn't comply with the statute of limitations and your claim was barred, would you have a takings claim because now you've lost what was earlier a valuable right?
No. In that case, in a tort case, for example, you're bringing an affirmative claim. You're saying, I'm entitled to damages because something bad's happened to me.
I think you did that in Shug 1.
We did that in Shug 1, and we're not here saying we're entitled to trespass damages, for example. But something else happened in Shug 1 in addition to us losing our ability to recover in Shug 1 trespass damages. We lost our property interest. That was the result of the ruling in Shug 1.
Wasn't the result of the ruling that you lost your ability to assert an interest in the property?
Yes, and that's tantamount to losing our property. When that happened, when the judge ruled that, we lost our property interest. We couldn't assert it anymore.
So it's never been established that, in fact, a property interest existed?
In the state court, no. In the Ninth Circuit, it has.
What if the state simply adversely possessed land that your client owned? You brought the case and you lost, and title was vested in the state. Do you now have a takings claim because you lost the trespass action?
No, because the trespass action that ripens into an adverse possession action is a claim to determine whether we have a property interest anymore. In that situation, Because we delayed 10 years, we lost our property interest.
And in this situation, because you delayed 1 year, you lost your property interest under the notice of claim statute.
We lost our ability to bring, to in the future.
How is that different?
Well, in the 10-year statute of limitations, the issue is whether the property interest has been extinguished. That's the purpose of adverse possession, is to extinguish a property interest. In this case, there was none of the underlying claims were to extinguish a property interest. Our underlying claim was for trespass damages and establish our property interest. We never got the opportunity to do that, and it was taken.
Adverse possession is just a statute of limitations on trespass, basically. Its purpose isn't to extinguish a property interest, but rather to settle rights based upon waiver over time. Isn't the notice of claim statute serving the exact same purpose?
No, in the notice of claim statute situation, the question for this court in inverse condemnation is when that statute of limitations arose for inverse condemnation. In the 10-year adverse possession, there's a 10-year statute of limitations, and one can determine whether that claim arose. The question in Shug 2 is when that claim for inverse condemnation arose, and that's never been determined.
Okay, but to establish a claim for inverse condemnation, you have to establish that you have some ownership interest. Let's take out ownership, just some interest in the property. Division 2 has said there is no interest in the property. So how can you proceed with an essential element of the case that Division 2 has already held you don't have?
We don't have it, and that precisely is the taking. The question is, did we have it? And as a result of that ruling, did we lose it? That's the precise
so you're
issue.
saying for the 80 years, you're entitled to damages. But how is your claim?
No,
It's
no,
like
I'm
retroactive
sorry.
damages? I mean, you're looking for damages in the past.
In this inverse condemnation case that's before the court right now, we're looking for damages for the value of that easement that we lost. That's the measure of damages. What's the value of that easement that we lost? The effect of the trial court ruling in Shug 1 is that that easement was extinguished.
I guess I come back to it, though. Why isn't that like saying, what was the value of the personal injury claim that I lost by not bringing it in time?
It's different. There's an underlying property value that exists, whether we bring a claim for trespass damages, for example, or not. There's an underlying.
It's a breach of contract claim. You have a debt, and you sell the debt to a factor. That's a property interest. You're allowed to transfer that shows in action. If you don't bring the action in time, are you then allowed to sue again and say, well, what was it worth? How much did we actually lose by not bringing the action in time?
Well, in this case, this case involves the state, where there's a specific right, where there's a taking
Let's say the
to
state
recover the value of the property.
The state enters into a contract to pay for services. It doesn't. The service provider waits 7 years to sue. Statute of limitations bars the claim. And now we say, state, you've taken our valuable claim. Let's find out what it was worth had we brought it timely. How is that different from
Well,
this case?
in this case, the state extinguished our valuable claim.
But you're asking us to assume, in fact, that is, in fact, the circumstance. Without being able to establish the existence of the interest, you're requiring us to assume the existence of the interest and then proceed from there.
No, what would have to happen in this case is the case should be remanded to the state court for two reasons. One, to determine if before in Shug 1 the court ruled whether there was a valid property interest. Make that factual determination. That factual determination's never been made. Number 2, determine when the statute of limitations for inverse condemnation began. The trial court has never determined that. The trial court has never determined when the substantial impairment of our property interest arose.
So you want us to modify the judgment to say Shug can never again assert an interest in this property, and then we would add, comma, except if he wants to recover its value. And that sounds like a pretty significant modification of a final judgment over which the Supreme Court declined to take review.
We're not asking that this court find, or that any court find, that we have a current existing property value. And so we're abiding with that judgment. We agree that that's been extinguished. The question is, 10 seconds before, did it exist?
But you would have to prove you would have to prove that this is it was in fact a valid easement, an easement by implication, a prescriptive easement. You would have to prove that on remand, right?
As element of inverse condemnation, we'd have to prove we had a property interest before the judge ruled, 10 seconds before the judge ruled.
Which would fly directly in the face of this court's opinion in Chug 1.
No, this court says we can't.
There's no right, title, and interest in the easement.
Yeah. We're not establishing that we have a right, title, interest in the easement going forward. Our position is to the contrary. We have none. And the question is what the value of that is that's been taken from us.
So anytime that there's a judgment entering quieting title,
Yes, sir.
cut down to the fewest words possible, a judgment quieting title, it's your position that as of the moment that that judgment quieting title enters, there's no further interest, but that up until then, wait a minute, I guess that's just a bad analogy. You're okay, I'll let that one ride. I'm not.
This is a unique situation.
Well, I guess what's unique about it is rather than this being the state reaching out and taking someone's property, this is someone losing their property by inaction. And I guess I'm still at a loss to understand why that's even compensable.
We lost our. Okay, well, there's two issues. One, did we lose our property, or a right to our easement? And the answer is yes, we did that in Chug 1.
And it wasn't because the state came along and said, we are taking your easement. It's because there was a dispute over whether you had an easement, you didn't bring it in time, and so by inaction, that right was lost. I'm struggling to think of any legal principle that would say that when you lose your own rights, somebody else has to pay for it.
What we lost is a right to establish our easement. We can't use that anymore. We can't use that easement anymore. So that right we've lost.
And you've also lost the right to assert an interest in it.
No, under inverse condemnation, there are two elements. Did we have a property interest, and that's never been established? Clearly we lost it. 10 seconds before, did we have it? That's what we need to prove.
Okay, that's element one. Then element number two, I'm hoping you're going to say, is was there a taking of that interest?
Was there a taking?
Okay, and at the moment you lost it, you're saying that there was a taking because the court held that your client abandoned the interest essentially by not bringing the action in time. How is that a taking?
That's the taking because a result of University of Arizona putting up the gate, as a result of University of Arizona bringing their motion for summary judgment and the court granting it, we lost a property interest solely through letting 15 months pass. That's unprecedented in Arizona, that not only can you not bring a claim, but you lose your property interest. Think about this analogy, Your Honors. Somebody trespasses on my property, on my house, walk from the state, trespasses. 15 months go by, they trespass again. And I know about the earlier trespass. And I say, wait a minute, you've trespassed on my property twice now.
Sounds like you're re-arguing Chug 1.
No, what I'm arguing is that there's a difference between me being able to bring a claim for damages for his trespass and do I lose my property interest? Do I lose my property interest in my house? Maybe I can't sue because I waited 15 months. Maybe I can't say I get damages, but I certainly don't lose my home because somebody from the state has trespassed for 15 months. That's
counsel,
exactly the situation we have here.
No, because in the house you're a deeded owner of record. There are any number of different issues that establish your ownership interest in the house. In this case, you were needing to go forward to prove the existence of the easement in a situation where there was no deeded title to you, there was no grant of easement, there was no official record indicating your client had an interest, simply that they had used the road apparently for some period of time. So when you were moving in Chug 1, what you were moving toward in Chug 1 was a determination of the existence of an easement, correct?
Correct. And we were never able to do that.
And you were, because of the statute of limitations, precluded from doing that.
Well, in that situation, it was because we brought a declaratory judgment action. And because of the declaratory judgment action, the court in Shug 1 found that the statute of limitations had run, therefore we couldn't bring a trespass action in that case. In this case, there is no declaratory judgment action that would
If in
bar
your
the statute of
situation,
limitations.
a state actor comes and trespasses on your house, you bring an action, and you get a judgment that says you no longer have any right to assert any interest in that house, and that judgment is appealed and review is denied, I mean, couldn't you be in a world of hurt anyway, no matter how unfair that might seem by virtue of res judicata? I mean, that would be the identical case. Yeah, you might lose your house in that case. The judgment might be wrong, but the judgment has been fully appealed, and it becomes final.
The judgment is that we lost our easement. And the judgment in that case would be you've lost your house. The state came and trespassed on your house twice. And 15 months passed and you didn't bring a claim. Very similar to what we've got with respect to, with the exception of the point Judge Jones raised. But assuming we can establish our property right. It's the very same case. In that situation, if the state comes and trespasses twice in 15 months and we lose our property, absolutely we'd be entitled to compensation for losing our property.
Okay. Unless there are other questions, I think we're out of time. Thank you.
Thank you.
May it please the court. My name is Jeremy Butler. I am an assistant attorney general representing the Arizona Board of Regents in this case. This case is nothing more than an improper collateral attack on the Rogers decision.
What did Division 2 decide?
Division 2 held, and relevant for purposes in this case, that Mr. Shug is barred from asserting that he has a property interest. And because he is so, he has no property interest. And therefore, he cannot create one or establish one in this case. And so there's nothing to be decided. At best, it's moot. At worst, Mr. Shug loses because of the arguments raised in the briefs.
Go ahead.
Simply put, Your Honors, I'm happy to handle any questions you have for me. Otherwise, we're prepared to rest on what we've put in the briefs.
You do agree, it is your position that Shug 1 was dispositive of the issue of interest and what follows?
Correct.
Is there any sort of revisiting of that issue that you believe is still up for discussion, still subject to litigation?
No. I cannot fathom any issue that is up for discussion. Even as opposing counsel indicated, he needs to establish some sort of interest to have some sort of value. He never even got the chance to do that in Shug 1.
Because?
Because he was barred from being able to do so because of the statute of limitations.
So he could never establish the interest that he needs to be able to illustrate in order to get damages for its taking because of the statute of limitations precluding his right to bring the claim.
Correct, Your Honor.
Thank you.
That's exactly his argument. I mean, that he was prevented from establishing that interest that is alleging existed for 80 years, that they had this valid easement that the state took away.
Well, he assumes he had a valid easement. He never actually established it. And that's what Shug 1 was all about. He chose to come by a quiet title action through a declaratory judgment action to prove his property interest. And he was barred from doing that.
And counsel, I know you've asserted several grounds or in your motion to dismiss and on appeal, but which is the strongest ground for, I mean, is it collateral attack? Is it collateral estoppel? Is it issue preclusion, claim preclusion? What is the strongest one in the state's opinion?
Your Honor, I've thought about that long and hard over the past weeks. I firmly believe the strongest at this point is this case is now moot because the dispositive issue has been decided. Going down, I think it is then barred by claim preclusion or res judicata. Then the statute of limitations also bars it, either because he is issue precluded from re-arguing that issue or because it applies based on the facts he's alleged.
Okay, thank you very much.
Thank you.
I'd like to thank counsel for the arguments. This matter is now under advisement. We will issue a written decision in due course and stand in recess to allow the next case to set up.